Buckle up for a wild ride in Harris County Court. Today, we're diving into a string of high-stakes DWI and reckless driving cases. From Ronald Umzor's near collision with cops to Manuel's firearm fiasco and Janiyah Alexander's bar-to-crash saga, the judge is laying down the law. Will these defendants dodge jail time, or will their bond violations seal their fate? With ignition interlocks, drug tests, and revoked bonds, the tension's sky-high. Stay tuned for jaw-dropping rulings.
Ronald Umzor.
Yes.
You speak English?
Yes.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 20th, 2025, an officer observed the defendant's vehicle in the street and observed the defendant talking to prostitutes on the street in or around the 3700 block of Tidwell Road. The officer followed the defendant's vehicle into a nearby motel and they were almost struck head-on by the defendant. A traffic stop was initiated. The officer observed the defendant to be the driver and sole occupant of the vehicle and observed the strong odor of alcohol upon his breath. The defendant refused to answer questions without a lawyer present. The officer observed the strong odor of alcohol upon his breath, slurred speech, and bright glassy eyes. SFSTs were conducted 6 out of 6 on the HDN, and the defendant refused the walk and turn in one leg stand. The defendant refused to provide a breast specimen.
That's not how I read the offense report. I read that after he almost struck them, they then followed him, and then he came to a complete stop in the roadway, and then they stopped him. So I don't see any traffic violation,
I'm looking at the dim side, Judge.
Okay.
And that's for me, it's a distinction from what was read to what.
It says they viewed the defendant speaking to prostitutes on the street and around the 700th block of Tidwell Road.
Talking to people.
Officer stated, sorry, Judge. Yeah, thank you. I'm just reading. Yeah. Officer stated that they followed the defendant's vehicle into a nearby motel and they were almost struck head-on by the defendant's vehicle as it exited the motel parking area. The officer then stated that they have activated their emergency lights in the patrol vehicle and got behind the defendant's vehicle.
Did they let him drive a little bit and then pull him over, or was it?
Yeah, he got into my understanding is he got into the roadway and then he came to a stop and then they stopped him. So I don't see any traffic violation. I don't see any crime being committed.
I mean, I don't know. I mean, perhaps there were. She's saying that he almost hit them, right? And maybe he went out a little bit more and then sees them, and I don't know.
No, yeah, they're asking you to assume.
Hits them, so at that point they pull him over. I mean, go get the video, go get body cam.
Sure.
You see something different.
Sure.
Always. I do think that there's sufficient probable cause to go forward with the case, Mr. Umzor. Can you run his license, please?
Yes. His driver's license is eligible, Your Honor.
I am now placing a restriction on your license, Mr. Umzor. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir. No, sir, Mr. Umzor.
Yes, sir.
Likewise, you are not to drive any vehicle unless it has an ignition interlock. I'm sending notice to DPS in Austin so that every single officer in this state knows if you're driving a vehicle that doesn't have a blow and go in it, they're going to arrest you and put you in jail. Do you understand?
Yes, sir.
I'm not asking much. All I want my streets to be safe, and I'm going to do everything in my power to protect it. You got a great lawyer here. Listen to Herman. He'll take care of you. Because you have a lawyer, I will waive your appearance, but you must stay in touch with him. If he tells me he can't get a hold of you because you're playing games and you've gone AWOL, I will issue a warrant for your arrest. For now, I'll have you go to Victoria Center Reset. We'll have you get with pre-trial for your bond conditions, and after that, you're free to go.
I think you already had the interlock and everything previously, and it's the agency. Okay, all right. Mr. Umzor.
So I'm here on Mr. Hunter.
Ronald Umzor's case sets the tone. A second DWI with signs of intoxication, slurred speech, glossy eyes, and a near collision with cops lands him strict bond conditions. Legal note: Texas requires ignition interlocks for second DWIs to prevent driving without sobriety checks, costing $50 to $100 monthly. Emotional stakes. The judge's no more PR bonds warning shows zero tolerance. Is Umzor's refusal to cooperate a bold move or a risky mistake? Should the court trust body cam evidence over the defense's claim of no traffic violation? Tell us in the comments as we shift to Mr. Hunter's drama.
He had an issue, he bond forfeited, he's back for an arraignment today. I've spoken with the state, they've made an offer. We're asking for one setting for Mr. Hunter to consider that offer, and then the state is going to eval the case if not.
Notice what just happened here. Mr. Hunter was bonded out, but the judge is immediately sending him for a drug test. This is a classic move in probation-style monitoring. Quick question for you guys. Do you think mandatory drug testing for bond should be standard, or is it an overreach? Drop your thoughts below.
If reasonable minds still disagree.
Where is Miss? I don't even see Mr. Hunter.
He's in here. Mr. Hunter?
Has he made
Yes, he bonded out.
sending him for a drug test right now?
Okay. Right.
I don't know what you have offered. I like it.
And just,
I'm going to tell you now that it's not going to be this revolving door anymore.
right.
No more revolving doors for you, Mr. Hunter. You understand? If I find that you're using, it will not go well for you. You come to court whenever you want to come to court. That's not the way it works. I'm sending you now for a drug test.
I know.
I guess we'll come back Monday and address the results because it's now 11 o'clock. I don't know.
Okay.
I just don't know if it's enough time.
Okay. And Mr. Hunter just informed me, he drug tested yesterday. So I don't know if we have those results yet.
The pretrial people,
Wait, yeah.
the pretrial people that I'm audited for drug tests make money out
I don't
there.
know how because there was no order from us. If he's on the land and then he makes bond, those bond conditions are valid. You know what I mean? So we can't just.
Got a report Monday.
Shh.
Okay, so when he was released, there were bond conditions in place that he needs to report on Monday and Thursday for drug testing.
Okay.
And so he did that yesterday.
Did you test?
Yes, Judge. We needed, from the drug test, yesterday, needed a consumption, deposit for.
Okay, I'll let you.
So, yeah, for the deposit for THC, window, oxy,
You will now test every Monday and Thursday. You test positive for anything else, it's not going to go well for you. You understand, Mr. Hunter? Now is the time for you, once again, to address any issues you may have. If you don't, I'm going to address it for you. Okay? So we'll let him go now.
Okay,
Continue with the same bond conditions that we've always had,
okay.
and then we'll test again on Monday.
And so just to let you know where this case is heading, the state has asked for one setting to eval it. And then if reasonable minds still disagree, then we're gonna set it for a dispositive motion to suppress with the court's permission.
I don't know. I'm just going to set up a trial.
Okay, we can do that too.
It's just way too much drama, man. I'm not going to, just
Well, we'll have to see.
let a jury decide.
So you'll go do we'll stand down, Judge.
Yeah, just, okay. Anna will continue like always. He's going to be back Monday and test.
Let's go.
Thanks.
Gooch, who is in custody.
We're bringing them out, Judge.
Okay. I'm bringing you out now because I have great concern with your cases and the way that your bonds were set at this time. It appears that in September,
Whoa, this escalates fast. Not only was he allegedly intoxicated, but now there's a firearm involved. Imagine being a juror here. Does carrying a weapon while impaired automatically make someone more dangerous, or is it just bad luck? Let's hear what you think in the comments.
of last year, you pick up a felony assault of a public servant and an evading arrest. A couple months later, an aggravated sexual assault. And I'm assuming he's out on bond for all this stuff, and now he's picked up another case? You now stand charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 17th, 2025, at approximately 2:46 p.m., officers were dispatched to 3099 NASA Parkway, Houston, Harris County, Texas, for an intoxicated male who had fallen off his bicycle and dropped his firearm onto the ground. Upon arrival, the officer observed other officers detaining the defendant and transferred custody to the affiant. The officer spoke to the witnesses who stated they observed the defendant in an intoxicated state, walking along the sidewalk and stumble onto the ground, and they observed a semi-automatic firearm fall out of the front pocket of the defendant's hoodie. Witness 1 retrieved the firearm from the defendant and handed it to witness 2. Witnesses then held the defendant until the police arrived. The officer attempted to question the defendant, but the defendant was unable to provide the officer information as to why he was in possession of the firearm due to his intoxicated state. And the defendant was identified via his U.S. residency card.
Does he have an ISO? Do you know? Mr. Cruz, I'm going to find that there's sufficient probable cause to go forward with your case.
He does have an ISO, Judge.
Did you have anything on?
Your Honor, I'd also like to add that a condition of his felony bond was to not possess a firearm. So it's a BPO.
I think Mr. Cruz, they give him chance after chance for you to remain out on bond. And I find by clear and convincing evidence that you refuse to comply with bond conditions. There are no non-financial conditions that we can do that will enable you to comply. As a result, I'm now going to revoke your bonds and I'm going to set them all at $10,004. Because of the actions now, I think that
He does have an ISO.
you now have an immigration detainer. So, do you know anything that's going to happen with that by chance? You know? Okay. So I don't know if you're going to get out. If you get out, I'm ordering you to be under home confinement. You are not allowed to be released unless you have a GPS monitor on your ankle. And then I'm also on your other ankle, I will put a scram monitor so I know that you're not consuming anything. You are not to consume alcohol, illegal drugs, unprescribed controlled medication. You're not to be in possession of weapons. Do you understand, sir?
Yes.
Okay. We need him to sign the conditions and then after that we'll set him. It looks like the felony is set for, May. Let's do 30 just in case, and then if nothing's happened in the felony, then we can do another 30 after that time. So, okay. Thanks. Alexander. Ma'am, you're charged with the offense of driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You are Janae Alexander?
Janaya.
So you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On March 22nd, 2025, an officer responded to a minor traffic incident. Upon arrival, the officer met with the wheel witness officer who stated that he was conducting a safety control of a disabled 18-wheeler on the shoulder with his emergency lights activated. The officer stated that he was on the shoulder when he was struck on the driver's side by the defendant's vehicle. After the crash, the officer observed the vehicle to continue to travel southbound. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and immediately detected the strong odor of alcohol upon her breath and slurred speech. The defendant exited the vehicle, and the officer observed unsteady balance. The defendant admitted to consuming alcoholic beverages prior to driving. The affiant officer made contact with the defendant and observed the same signs of intoxication. The defendant stated that she was on her way home from a bar and consumed 1 mixed drink at 9 p.m. The defendant stated she was unaware of when she struck the patrol vehicle. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues observed on the walk-in turn. 2 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were .202 and .201.
Any prior DWI?
No prior, Judge.
License?
Oh, yeah.
Okay. Ms. Alexander, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Ma'am, look at me. If I find that you're using, it's not going to go well for you. I'm not asking much from you. If you do not have a valid Texas license and liability insurance in your name, car insurance, you're not allowed to drive. That is also a condition. Do you understand? How old are you, ma'am? You're
23.
Do you have the ability to hire a lawyer? Would you like to apply for a court of conviction?
Yeah, I don't have, I need one.
Okay. So Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you sign a receipt. Victoria will have you take a seat in the jury box while you fill it out. You will meet with pre-trial bond conditions, then I'll have you talk to someone here shortly. Okay? Please. Are you Victor Ortiz?
No, Judge.
No, this is Osman Rodriguez.
Yes.
Mr. Rodriguez, you're charged with driving.
Janiyah Alexander's case is a wake-up call. Her DWI with a staggering 0.202 breath test after crashing into a patrol car screams trouble. Legal note, a Class A misdemeanor DWI in Texas, elevated by high BAC, carries up to a $4,000 fine and a year in jail. Emotional stakes. Her claim of 1 drink contradicts the evidence, and the judge's stern warning shows no patience for excuses. Is Alexander's youth a factor for leniency, or does her reckless crash justify harsh consequences? Drop your thoughts below as we move to more high-stakes cases.
While intoxicated, you're facing up to a year in jail and or $4,000. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 21st, 2025, an officer responded to a 2-vehicle accident that occurred near the 5,000 block of Bingle Road. The complainant stated that she had made a right-hand turn northbound on Bingle Road and was already traveling northbound when she was struck on her driver's side by a white van. The complainant identified the defendant as the sole occupant and driver of the striking vehicle. The officer made contact with the defendant and observed red, glossy eyes, the strong odor of alcohol upon his breath, and sweat. The defendant stated he consumed 2 beers, 1 at work and 1 in his vehicle as he was driving home. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 4 clues on the one-leg stand. 3 out of 8 clues on the walk-in turn. The defendant consented to provide a breath specimen. The results were .160 and .177.
Did they find alcohol in the car? Substantiate that allegation.
doesn't state in the VIN, Judge.
Does he have a license and any prior DWIs?
He does not have a driver's license and no prior DWI.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with the case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. That is a condition of your bond. I will have you sign with me today a promise to me that you're going to make. This is an affidavit that I take absolutely serious. I don't care what's going on in your life. I don't care if you have a bunny that needs operating. If I find that you drive, it's not going to go well for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and you will be randomly tested. If I find that you're consuming, likewise, I will revoke your bond, put you in jail. No more PR bonds for you. You have a lawyer. Because you have a lawyer, I will waive your appearance. Mr. Rodriguez, it is your responsibility to stay in touch with him. If Mr. Salinas tells me that he can't get a hold of you because you're playing games, you pick up a new case, you endanger my community, I will put you in jail. For now, I'm going to have you come up here and swear to us that you're not going to drive. I will get you to Victoria, we will have you sign a reset, and then after that, I will get you with pretrial, and then after that, you're free to go. Come on.
Yes.
Mr. Sierra, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer observed a vehicle engaging in illegal street race at the 12,425th block of Wood Forest Boulevard in Harris County, Texas. Both the defendant's vehicle and another vehicle passed the officer at a high rate of speed while attempting to pass each other in a competitive manner in an attempt to outdistance each other. The officer observed the defendant drive 96 miles per hour in a 40-mile-per-hour zone. A traffic stop was initiated. The defendants began to pick up speed while swerving through multiple lanes and cutting off other drivers on the roadway in an attempt to outdistance each other. The defendant admitted to speeding but denied racing. The co-defendant is a juvenile.
Got you, question on record.
You want his license? See if he has a license.
Yes, Judge. He does not have a driver's license on file, Your Honor.
Mr. Sierra, I'm going to find that there's sufficient probable cause to go forward with the case. You do not have a Texas driver license. You are not allowed to drive. I'm going to have you sign with me today an affidavit, a promise that you're going to make to me that you're not going to drive. I don't care what's going on in your life. If I find that you drive, I will put you in jail. And if you're not in this country with permission and you go to jail, it's very possible immigration puts a detainer on you and you will be in there until this case is over with. How old are you, sir?
20.
Did you want to apply for a court-appointed lawyer?
Sí.
Yes.
Look at me. Heed this warning. Get no more. If I find that you're a danger to my public in any way, I will put you in jail in a moment's notice. Do you understand? Think before you act. You hang with the wrong people, it's not going to go well for you. Come on. All right, Mr. Wong, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 18th, 2025, an officer was dispatched to a call for service in reference to a major crash. The witness stated that he observed the defendant sitting in the front driver's seat behind them and crash into another vehicle by rear-ending it at the 9,000th block of Bel Air Boulevard. The witness stated that he observed the defendant was driving recklessly prior to the vehicle crash. The officer observed a strong odor of alcohol emitting from the defendant's breath, slurred speech, glossy eyes, and slightly unsteady balance. The defendant admitted to consuming an unknown amount of alcohol. SFSTs were conducted. 6 out of 6 quickly served on the HGN, and the defendant was unable to perform the walk and turn test in one leg stand due to a past ankle injury. The defendant consented to provide a breath specimen. The results were .123 and .122.
How many prior DWIs? Have you run an NCIC?
Yes, he has 1 prior DWI.
Here, anywhere else, anything else? No? Okay, license?
I can check.
He does have a friend, John Wall.
Right. That's who it needs to be, not Andy.
That's the
His driver's license is eligible, Your Honor.
All right, Mr. Wong, I'm going to find that there's sufficient probable cause to go forward with the case, and I'm
So here's the takeaway. Even with prior offenses, the court is willing to give Mr. Wong a chance, but only under strict conditions like ignition interlocks and bond monitoring. It's a balancing act, second chances versus public safety. Stick around, because the next case raises the stakes even higher.
ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. No more PR bonds. I am now also placing another restriction on you because it's a second offense. I'm ordering you to obtain an ignition interlock, and you're not allowed to drive any vehicle that doesn't have one. If you're caught driving a vehicle that doesn't have one, you will go to jail. Do you understand? I'm sending notice to DPS in Austin so that every single officer in the state knows. Do you understand? Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with the other Mr. Wong, and he'll tell you if and when you have to come back to court. For now, I'll have you go to Victoria, sign a reset. You'll get with pre-chopper your bond conditions, and then you're free to go.
Judge, June 3rd through the 5th.
Mr. Wong, did you hear that?
Yes, I did. Your Honor, I just have one question. The vehicle that he is driving to and from work.
Is that what you were about to say? Come on up. So,
the ignition. I'm sorry, Judge. Go ahead.
is it inoperable, I guess?
It's inoperable at this time. We don't even know if it's going to be repairable, but the point I'm trying to make is that the vehicle that he drives, he shares with his mother. So I don't know if with the ignition, the system, if that's going to be something that...
You're not allowed to drive any vehicle that doesn't have an interlock on it. So if you're going to drive mom's vehicle, it has to have an interlock on it, and that's it.
Okay. That's just okay.
No, I don't want you driving any vehicle that doesn't have an interlock. I mean, I want to make sure that if you get in the car, there's no alcohol on board. That's it. So if you want to get a portable device and you're telling me you're not going to drive, I'm going to have you sign an affidavit promising me you're not going to drive. So, you know, whatever vehicle you put it in, or if you're going to drive, okay, you got to have one. You make the decision.
Yes,
if you want me to give you a portable device, I'm happy to do that, but you're going to promise me you're not going to drive it. Okay. So I guess just let them know what you want to do. I mean, if you want to take time to think about it, you know, I'm happy to give you time as well.
Yes, Judge, that would be great. Let me confer with my client, and then we'll decide.
So, you know, go outside, step outside, you talk, and then when you make your decision, just let us know. Okay?
Okay. Thank you, Judge.
Sure.
Judge, I'm gonna get on the side.
Yeah. Good morning, Mr.
Good morning, sir.
Sir, you're charged with reckless driving. You're facing 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 21st, 2025, at approximately 10 p.m., an officer was investigating a fatal motorcycle accident with emergency lights activated, and the road was shut down from both directions. Accident investigators notified dispatch of a vehicle which disregarded all marked units and drove through the accident scene, almost striking officers and record drivers at the crash site. The officer observed the vehicle traveling at a high rate of speed and cut through an Exxon service station parking lot and turned down another road. The officer followed the vehicle and initiated a traffic stop. The vehicle accelerated and began darting in and out of lanes without using a turn signal. The vehicle then turned and came to a stop. A high-risk stop was conducted and the defendant was taken into custody. A security sweep of the vehicle was conducted and the officer observed 2 baggies of a green leafy substance in plain view on the driver's side seat, known from training and experience to be marijuana. The defendant was identified by a sexy driver's license, and the defendant was transported back to the accident scene, where the accident investigator confirmed the defendant's vehicle was the same vehicle that disregarded the marked patrol vehicles and disregarded the safety of the people on the scene. Other officers who witnessed the defendant's vehicle confirmed this. Deputy Chicoya advised that the defendant's vehicle almost struck multiple patrol vehicles and had approached officers while they had to abruptly move out of the way. And then Deputy Chicoya observed the defendant's vehicle almost strike 2 record drivers who were authorized to be on the scene. The record drivers confirmed this. Witness Cross advised he yelled at the vehicle to stop, and the defendant's vehicle began to accelerate faster. The defendant acknowledged he drove through a roadway.
Mr. Davis, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license? Please see that.
His driver's license is ineligible, Your Honor.
Mr. Davis, you are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care if Jesus comes from heaven and needs to ride to church. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
So,
I'm going to do everything in my power to protect my community. If I find that you drive, much less drive maniacally like this, as they allege, it's not going to go well for you. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, if you do, it's not going to go well for you. You have a lawyer because you...
What a whirlwind in Harris County Court. Ronald Umzor and John Wong face strict ignition interlock conditions for their second DWIs, while Janiyah Alexander's 0.202 BAC crash earns her a no-driving order. Manuel's bond is revoked for carrying a firearm while intoxicated, compounded by prior felonies. Osman Rodriguez and Mr. Sierra face driving bans, and Mr. Davis's reckless driving with marijuana seals his fate. Legal takeaway: Texas cracks down hard on repeat offenders, with bonds revoked and devices mandated to ensure public safety. Was the judge too strict, or is this tough love necessary? Hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.
You have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you that you're playing games, you're not responding to phone calls, text messages, you've gone AWOL, you pick up a new case, I will revoke your bond and put you in jail. Do you understand?
so,
I'm not asking much. All I want my streets to be safe. That's it. I'll have you come up here, swear to us you're not going to drive. I'll get you to Victoria, sign a reset, and then you're on your way. Thanks.
Okay.
All right? Please.